Oyez, oyez, oyez. Anyone having business before the King's Justice, the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all.
Morning.
When you're ready, Mr. Schachter.
At the end of the day yesterday, we were talking about the legal fees, the counsel fees, and whether it should be part of the compensation award or whether it should be dealt with as costs and the idea of full indemnity. My friend for Canada was concerned that I had perhaps not made a matter clear with the court. I thought I had, but I am going to repeat it so that we're ad idem on this. We had sent communication on January 24th to Canada, identifying the exact amount of the counsel fee of $100 million prior to them releasing their January 27th decision. What Canada says and what I accept, because my friend has told me this is the case, is that when they made their determination to contribute $40 million to costs of the trial and the negotiation session, they had not factored in that they had received notification that it was 100 million as opposed to 255 million or 500 million. It could have been any number. They didn't know what it was. And I accept my friend's advice that that's the case. I have no reason to doubt her on it. So I hope that clarifies that. I don't think it matters, but
I think that's what I had understood.
Yes.
And possibly I mangled it when I fed it back to you, but that's what I stood. Canada had a letter that had gone through an approval process that ultimately was sent out on January 27th, but had been in the works and possibly finalized before they received your letter of January 24th. Is that how you understand it?
That isn't exactly the facts, but how I've stated it, which is because the letters are different. The draft letter and the letter that went out are not the same.
Oh, okay.
Right? So, not exactly.
But then I'll make sure that I do understand it. That the letter and the position taken by Canada on the 27th of January was made without knowing how.
Without knowing the quantum.
Without knowing the quantum.
The quantum of the counsel fee. Right? And I say it really doesn't matter whether they knew the quantum. It matters whether or not they should pay what's fair and reasonable. Now, I want to turn for a moment to reasonability. And you're going to see that reasonability matters in the engagement process. And I want to talk about the engagement process and the reasonability that the RST and Anishinaabe brought to that engagement process. And I want to do this by sort of having the court appreciate that in the engagement process, the First Nations were striving, and when you read the record, you'll see this yourself, striving time and time again to come up with ways to crack the nut, come up with ways to compromise, come up with ways to achieve a result that would be honorable. And one of the things that they realized is let's try and tackle and deal with the issues that keep us apart, and let's try and see if we can come to a resolution by, instead of forcing a decision on a particular issue or agreement on a particular issue, work around an issue. And I want to take you to tab 11 of the compendium. Tab 11 was of the compendium was David Hutchings' December 2nd, 2024 report, wherein the Superior Anishinaabe asked Mr. Hutchins to run a number of different calculations using different assumptions. We're going to be going to page 142 of the compendium. And the reason, and I think Mr. Hutchins was chided by Mr. Bodway as just simply number crunching. But the number crunching was requested by the superiors, First Nations, to try and bring some reasonability to a range. And this is why, although you might not be able to fix on one correct certain number, that it's only one number that could possibly be the correct number. And I don't say there's, given the lack of specific details, there can't be a mathematical certainty to this. But given what I'm about to tell you and show you, and what the Robinson Superior Anishinaabe were trying to do, is to try to give some semblance of where the reasonable range might lie by reference to trying to remove some of the barriers to reach an agreement. And so at page 142 of the compendium, we had Mr. Hutchins run numbers on the basis of removing forestry NCRRs and rents after 1960. Now, you might remember at stage 3, one of the big issues was, look at all the forestry expenses. And so we said, well, let's try and eliminate that as a problem. What if we simply said, forget about forestry revenues and expenses, take that out of the mix? Where would that leave you? And if you look at this chart, and I'm just going to use the band trust account to 51 and the 60/40 rate, just and columns, and the NCRRs plus 25% of rents, you still get, even if you remove that impediment, in the range, and this is 100% of the NCRRs plus 25%, of 62 billion to 84 billion, without understanding what the Anishinaabe share would be, right? That's under the last two columns, under 100% of NCRs plus 25%. Right? And so, and if you take it at 50%, you can see, you know, there's different machinations. Of course, the 84% was taken because that's the Stiglitz and Hutchins, one of their analysis was the risk factor, and that might be a percentage that they should take. But we took it down all the way to 50%, just to give some semblance of an idea. And the purpose was to say, look, let's remove this impediment to a settlement. Where does that take us if we remove that impediment? Not that we agree that you should remove all forestry revenues, not that Mr. Hutchins was wrong, but let's assume, let's try and remove that as a problem. And you still get, even at 50%, you get to over $31 billion. It's not that much different than if you just left the forestry in.
You get to 30, is that what this number is? You get to 31 billion under the BTA?
No, under BTA, sorry, under BTA to 1951 and 60/40 thereafter, you get to 31 billion. Under BTA alone, if you just did it BTA for the full period from 1850 to 2019, you'd be left with 6.8 billion.
Sorry, that's what I was looking at. It's BTA to 51, 60/40 thereafter is 31.
Yes.
So the 50% of NCRRs plus 25% rents without forestry gets you these numbers.
That's what this chart is all about. It's all about eliminating forestry as a problem. And it's not because we think you should that Hutchins was wrong to include in positive forestry amounts, but it was to remove the problem that Ontario's experts claimed existed, which was, and Hutchins said existed as well, was the huge forestry losses, right? If we just try to
Removes it to the benefit of the plaintiffs if you remove the forestry losses.
What also removes the forestry revenues too.
Right, but if it's net, the Crown was saying that there were net losses.
Right, right. So, but this was an attempt to try and remove that issue, to try and be reasonable in an approach that says, look at, let's try and remove that as an issue. Over on the next page, we tried to.
I just need 1 second.
Yes.
So the range at 50% is from depending on the BF rates, is from 6 billion to 42 billion.
That's right. That's right. And simply what that tells us is by removing this issue, a $3.6 billion amount is still way outside the range, right? Another issue that we had at stage 3 was how do you deal with expenses after 1945? And we then asked Hutchins to run numbers about, well, what would happen if you just took the position that, what would have happened if the Crown had woken up on the morning of January 1, 1946 and said, I have an obligation here to make a treaty payment. If they had only realized it on January 1, 1946 and had done it honorably at that time, what might it have looked like at that point? Pretend there is zero revenues, zero expenses after 1945. What does that look like? And not that we think that the Anishinaabe are entitled to nothing after 1945, but for the purposes of identifying a past compensation amount globally, take a look at where these numbers take us. Again, I'm focusing on BTA to 51 and 60/40 thereafter, and NCRRs plus 25% because the evidence was pretty strong in terms of NCRRs and 25% of, if it's not rents, it's 25% of something, or sorry, it's something on top, which Ontario says would be 25% of NCRRs. But in this chart done up on 25% of rents, you see that at 100% up to 1945, you're still looking at over $27 billion. And at 50%, you're looking at over $13 billion. Now,
I need you to slow down.
Yeah.
Okay, go ahead.
Yeah. So we're talking about the last two columns of BTA to 51 and 60/40 thereafter.
Yes.
And if you look at 100%, the third major row, NCRRs plus 25% of rents in excess of NCRRs, you get a range of 27.788 billion to over 50 billion, or at 50%, 13.8 billion to 25.12 billion. And so the purpose of this was not to agree that there should be no revenues after 1945, but to say to the Crowns, look, let's be reasonable about how we can approach a global figure. Let's try and remove the idea of what would happen. if the Crown just woke up in 1945 and realized it should make a payment. Now, true, at band trust account rates, it's only $2.3 million, right? $2.3 billion in 1945, right? That's the BTA column. But we, trying to be reasonable, we've shown all the machinations, but if the range is between 2.3 billion and 25 billion at 50%, or if the range is between 4.6 billion and 50 billion at 100%, as the chart shows, 3.6 billion would miss the mark because that's just globally, considering that maybe there might be some wealth to share after 1945. This is even if you just forget about anything after 1945 and you sort of weigh it in some holistic fashion. If you want to use the holistic fashion approach, it doesn't make sense to say 3.6 billion falls within a range of acceptable outcomes. And that was the purpose of the First Nations trying to engage the Crowns in a reasonable, reasonable approach to looking at things more globally by demonstrating to the Crowns that the amounts that need to be paid to be honorable have to at least take into account what the result would be if you removed these major impediments they were complaining about in the stage 3 about Mr. Hutchings' analysis. And again, the importance for today is reasonability and the reasonableness of the Anishinaabe position and how reasonable they were in the engagement process. On the issue of the engagement process itself and whether it was honorable, I want to first take the court to paragraph 3 of the Supreme Court of Canada decision, which my colleague will bring up on the board. Well, on the board on the computer screen. Boy, that's old school. Okay.
I just, one thing.
Yes. It's the last toward the end, remedying the truth. Yes.
Got you. Good job. Thank you.
Go ahead.
So at the end of paragraph 3, the Supreme Court of Canada says, remedying this failure, that's the failure to honor the treaty bargain, and restoring the honor of the Crown requires returning to the foundations of the treaty relationship between the Anishinaabe and the Crown. And at paragraph 4, continuing on, the foundation that the treaty, the Supreme Court of Canada reminds us, is that it was built on a close relationship between the British and the Anishinaabe of the Upper Great Lakes that existed long before 1850. They go on to say, the British and the Anishinaabe maintained the connection in part through annual gift giving around the sacred fires. This idea of annual gift giving, of assessing things on an annual basis, is not only how the presents worked, it's how the annuities worked as well on an annual basis. And it was an annual basis around the sacred council fires as expressions of mutual generosity and goodwill, says the Supreme Court of Canada, quoting from Dr. Bohacker. And at paragraph 13, the Supreme Court of Canada reminds the Crown what has to be done here. This is towards the end of their of paragraph 13. They are living agreements embodying a relationship nurtured over many years before 1850 and requiring ongoing renewal into the future. It is time for the parties to return to the council fire and rekindle the perpetual relationship that the Robinson Treaties envision. Nothing less will demonstrate the Crown's commitment to reconciliation. This, we say, the Crowns did not do. What is a council fire? When the Supreme Court of Canada talks about the council fire, they're not just talking about a fire in a teepee or in the community. It's a metaphor for a relationship. At paragraph 284, the Supreme Court of Canada reminds us that that relationship is a relationship of equals. They say the treaties concluded between the parties was fundamentally alliances of equals founded on the principles of mutual respect, mutual responsibility, reciprocity, and renewal, quoting from the Stage 1 reasons. It wasn't simply it's not simply for the Crowns to consider the Anishinaabe perspective on responsibility, reciprocity, renewal, and respect. It's a joint foundation that those principles, Anishinaabe principles they may be, but Anishinaabe principles that the Crowns embraced and must not just be given lip service, if I can be so bold. In the engagement session, I think they were, but be embraced by the Crowns in renewing the relationship in a way that was present in 1850, but evaporated shortly thereafter and needs to be, to use the words of the Supreme Court of Canada, rekindled. At paragraph 303, the Supreme Court of Canada is even more specific about what it means to return to the council fire and what engagement is about. At the end of that page, end of that paragraph, the details of the relationship must be the object of permanent negotiations in view of fleshing out the general principles governing the relations between the two peoples. I've referred to that paragraph before, but I want to emphasize it because it tells the Crowns exactly what they're supposed to do in the engagement process. And that's flesh out the general principles, put meat to the bones. It's not simply about them picking a number that they feel is appropriate, about true and meaningful engagement of equals, and respectfully, Ontario and Canada missed the boat. Ontario's factum, argument page 128. Ontario says it was not improper for the Crowns to decline the RSFN's proposed agreement on decision-making criteria. The Crown could not commit to predetermined weight for each factor and the factor that would need to be weighed by the Crown absent settlement. To do so would be to fetter the very discretion the Crown was constitutionally obliged to exercise under the treaty. The constitutional nature of the discretion meant that the Crown could not define in advance how much weight it would give to each fact or factor. That respectfully puts us in a world where there can never be any fleshing out of general principles, because that puts us in a world where we cannot of the relationship, and this is not what the engagement process was to be about. If you go to Compendium tab 21, you will see in a nutshell what the Anishinaabe were trying to do. At Compendium page 220, Compendium tab 21, there is a letter from myself dated October 1, 2024, still early, relatively early in the engagement process. This letter represents the current views of the First Nations on the subject, and we believe the decision-making criteria or factors set out herein are relevant, just, and honorable, and provide for a transparent, predictable, and rational process that will lead to a just result if adopted and honored. And that's what the Anishinaabe were looking for, a transparent, predictable, and rational process. And if you look at the attachments to it, to this letter, there's significant criteria. Now they're identified as agreed upon decision-making criteria. They hadn't been agreed upon, of course. We were proposing that these criteria could be agreed upon. Did we insist or say that the Crowns must agree to everything that the Anishinaabe said was reasonable and appropriate? No.
When I read this the first time,
Yes.
I thought this reads somewhat like an agreed statement of fact. Is that the nature of it? I can't tell you that I have perfect recollection of each of these. But some of the statements start out, the parties agree that, but
Yes.
another statement might start out that
I think it's okay.
paragraph 34.
Yes.
The stage 3 trial record provides the best evidence available to.
Right. Yes. Yes.
Or 37, the decision must be consistent with.
Yes.
Okay.
It's fair to consider it as an agreed facts or an agreed process. We were trying to reach agreement on a transparent, predictable process that we could feed in information to. Did we expect the Crowns to agree on every single item? No. Did we expect engagement on them? Yes. That we did not get. We got them listening to us, but we did not get engagement on the actual parameters of how the treaty would be implemented. What the Anishinaabe were trying to do was to work with the Crowns to agree on a process on how to implement the treaty. Surely that's what the Supreme Court of Canada wants of us. Work together to implement the treaty, for God's sakes. Yes, retrospectively for the past in this first engagement session, but nonetheless, work together to work out the details. Not simply to just, I think at some point a number of the chiefs were if not me, a number of the chiefs were complaining that we just seemed like we were there to blow off steam. And it's not as though, to give you an example of just how reasonable the First Nations were in the process, I think I've referred to this before, but we don't need to turn it up right now, but at trial record 1316, you will find the draft agreement that I took the court to earlier. It's a draft annuity augmentation engagement agreement. And throughout it, the structure of it was, here in Schedule A is what we can agree to as to how you're going to exercise your discretion. Here in Schedule 2 is what we said you should be doing, but you don't want to do. Here in Schedule 3 is what you said you want to do that you will be doing. So we gave the Crowns a draft that allowed them to just tell us what you agreed to and how you are going to do it. If you disagree with us, at least confirm in this document that you've heard us and you understand us and you disagree with us, and give us, and hopefully we would have reasons as to why you disagree with us that made sense. But at least we would have some flesh to the bones. Maybe we couldn't agree to it all, but at least we would at least know what we could agree to and what we couldn't agree to. And that would have provided a better way for a better opportunity for the Anishinaabe to assess, is the decision itself just and honorable? And it would have provided the court with even more ammunition to consider the decision it's got to consider. That opportunity was lost. It was unreasonable, incorrect, whatever standard you want to talk about, for the Crowns to refuse that olive branch and to say, we're here to listen. At paragraph 220 of the decision, the Supreme, sorry.
When you say that Crown said, we are here to listen.
Yes.
Do you have references from minutes or letters?
Yes, I'm sure that Ms. Lewis.
And maybe they're already in the factum.
They probably are, but I don't have them at my fingertips, and I will respond to that. Or if I don't before I leave, then Mr. Bass will help the court with that.
Or give you an opportunity to.
Well, yes, I'm sure he can find them. Or I can give them to him and he can tell the court. I want to, paragraph 220 of the Supreme Court of Canada decision, which needs to be brought up on the board, on the screen, computer screen. So at paragraph 220, the Supreme Court of Canada is talking about the honor of the Crown as a powerful constitutional document and speaks to how obligations that attract it must be fulfilled. At the same time, it is not a mere incantation, but rather a precept that finds its application in concrete practices. And throughout the engagement process, what the Anishinaabe thought they were engaged in, remember I talked about putting flesh to the bones or working out their details. If the honor of the Crown finds its application in concrete practices, what the Anishinaabe were trying to do is identify what those concrete practices are. Indeed, in their correspondence with the Crown, they expressly identified, here are factors that the honor of the Crown, or concrete practices that the honor of the Crown should give rise to.
When you say in their correspondence with the Crown, they expressly identify, these were in that October 1st letter.
I'm
in
looking
that
for the,
letter.
I'm looking for the letter, but there's, I seem to have misplaced exactly which letter it is. Just hold on. I'm pretty sure I had it in my compendium. Be the letter, our letter on factor 5. November 21st. That's the response. That's the response. I believe we're looking for our initial letter just prior to that. If it's not in our compendium, then maybe we can make reference to it. We can pull it up on the board, just on the computer screen. It's the one with all the factors. I say, what's the document number? Give me a number.
Go to page 2488.
2488. Hold on.
Who needs computers?
What's that?
Who needs computers?
Exactly. Right. Okay. So it's actually our November 13th, 2024 letter that starts at record page 2484 that seeks to identify factors or the requirements, duties flowing from the honor of the Crown. It starts at page 10. So I don't intend to go through them all. I don't think there's a utility to do it right now. But the point is that what the Anishinaabe were trying to do is to do what the Supreme Court of Canada told us we should be doing. And what the law requires to create some concrete practices that the honor of the Crown leads to by agreement, rather than leaving it to general statements of law about, well, the honor of the Crown requires diligent and purposeful implementation. Well, yes, of course. But what does that really mean on the ground? What does that mean for identifying how often you advert to the receipts? Is it on an annual basis, for example? That's a concrete practice. Another concrete practice is, what revenues do you look at? I mean, these kinds of very concrete things we were looking to flesh out. And what we got back at the end was, we will listen and we, the Crowns, will make a decision. The Crowns failed to identify concrete practices to 528. Excuse me. So on November 21, this is at tab 17. It's a November 21st letter where we respond to Canada and Ontario's correspondence regarding Factor 5, the honor of the Crown. The second paragraph, where the parties seem to differ is that unlike the First Nations, neither Crown identifies how the principles translate into specific duties within the treaty implementation process generally, or specific duties or specific responsibilities that provide insight into how the past compensation amount can be honorably identified. So I think it's fair to say that we were very disappointed that there wasn't any concrete approaches being taken by the Crown. The Crown simply repeated that they should act with honor or seek to fulfill the purpose behind the promise. And we complained that if that's just an articulation of legal principles, those principles are not the subject of the engagement in negotiation. They are euphemisms that without elucidation do not advance reconciliation. Respectfully, the task at hand, we said, is not simply to identify principles in the abstract. The task at hand is for the parties in the engagement process to jointly identify the concrete practices and specific duties that have arisen in the unique circumstances now facing the parties. And we reminded them at paragraph 3 that the Supreme.
You started out earlier, possibly Monday, that the past compensation would be arrived at by looking at three categories of things. The revenues, that's right. The major categories being benefits, NCRRs, revenues, however that's called.
Yeah.
The sharing percentage.
Yes.
And the bring forward rate.
Yes.
And the Crowns added something else possibly to that mix, and that is the RHT settlement. Right. On those four matters, were there discussions?
Were there discussions? Yes, I couldn't say that there weren't discussions, but there was.
Did you call them debates?
No, there was the Crown's. A good example would be on the Huron $10 billion settlement. The Crowns wouldn't even tell us what their position was on it. They simply said, it may or may not be relevant. We haven't decided yet. So I don't know, would you call that discussion? I wouldn't call it engagement. I'd call it, they told us that they weren't deciding yet on the issues of NCRRs and the like. There was exchange of views, but there was no engagement on those views. So
would you say there was negotiation?
No, I would not classify it as negotiation. I would classify what happened in the engagement process as the Crowns listening, us talking, the Crowns taking notes, and then the Crowns deciding. There was not the council fire engagement that was expected. It's that stark, and you can get a sense for that from reading the minutes and reading the letters that were exchanged. Yes, here's thank you, Miss Lewis. This encapsulates it. Jeremy, that's for Canada. That's page 3874 of the record. Jeremy, that's Jeremy Morrison for Canada, explained that the purpose of the current engagement process is for Canada to listen to the RSTN's views on the 5 factors in order to get a mandate to present an offer on December 20th that reflects what has been discussed. So that is a fair encapsulation of what I'm trying to convey, which is no, I would not call that engagement. I would not call that negotiation. I would call that perhaps something different than what the Supreme Court of Canada had in mind. At page 3949, Chief Tangi, and this is at a meeting of, what was the date of this meeting? Yeah.
Read it first and then I'll tell you.
Okay. I'll tell you in a moment when that was, but Chief Changi reiterated that the negotiation process has been one-sided, with Ontario and Canada merely listening and saying, we'll bring it back. She urged a change in narrative and called on the Crowns to step up and start making genuine concessions. There was no negotiation in the engagement session. I shouldn't say there was no negotiation at all. I think towards the very end, the minister showed up for 2 days or 2.5 days, but that was not the kind of engagement at the council fire that we were looking for. Yeah, that was January 7th, 2025 minutes.
3949.
Page 3949 of the record. Thank you, Ms. Lewis.
Thank you.
So to summarize the problems with the engagement process, we would say it's this. It was not an engagement of equals. It was but a Vidal and Anderson meet and greet and tell us what you're thinking. It was not a return to the council fire. Just again, if we can pull up record page 3829. These are meetings of minutes of October 24, 2024. Just to give you some further flavor of why we say this to be the case. (3829). Chief Tangi added that they would no longer accept the egregious way Ontario treats the RSTFN. She stated that it is very important for Ontario to take to heart the concepts of respect, reciprocity, and renewal for the nation-to-nation relationship with RSTFN. She called on Ontario to stop saying that it would consider or think about what the communities were expressing at the table and instead provide substantive responses to the questions being asked. Is there a no? Okay. That's a period. Okay. Questions being asked. I thought it was a comma. Over at page 3842 of the same meeting minutes of October 24, 2024. We have Chief King expressing concern about the outcomes predetermined in the statement of work.
What's the statement of work?
That the statement of work had to do with engaging the statement of work. Is that the factors or the Janice? That's the experts. Right, we were talking. Yeah. That was, yes, we had wanted to jointly retain experts and the Crown said, we just want to do it on our own. And Chief King was expressing their valid concern that, well, you know, you're just going, we need to have some input into the statement of work because you can drive the result you want by asking the right, whatever questions you want. Let's try and give the decision maker the best possible chance of making a correct decision by working together to engage an expert, but that was denied to us. The second major problem was the Crowns did not send people with authority to negotiate and renew the treaty relationship. Third, the Crowns refused to entertain coming to any type of agreement about how the treaty augmentation promises would be operationalized. And fourthly, as the instance of refusing to cooperate in engaging additional experts, the Crowns refused the opportunity for new economic evidence to be discussed or debated in some jointly designed process to ensure that only credible and reliable economic evidence would be relied upon by a decision maker. Respectfully, what we feared has happened. Without engaging the experts, the Crowns simply produced reports that their experts produced, specifically Mr. Bodway, and simply chose to rely on the opinions of their experts to the virtual rejection of experts' opinions brought forward by the one witness in the engagement session, David Hutchings, whose credibility, reliability, fairness, and accuracy was both trial tested in stage 3 and demonstrated to be fair, reasonable, objective, accurate, credible, and reliable. So those are the broad strokes of why the engagement process didn't work. Unless there's any questions about that, I would turn to a remedial approach.
When I just do have one question.
Yes.
On your third point, when you say the Crown refused to obtain ways of coming to an agreement about how the treaty promises would be operationalized,
yes.
Were you focusing on future
No,
negotiations?
this was for the past.
For the past only.
Now, when you look through the material, you will see that one of the criteria or operationalized principles we asked the Crowns to consider was some sort of discussion of how the future might look, because, and I said it here and we said it a number of times, if it's true that you're going to maintain that there's nothing for 300 years, then what we can accept in this engagement process is different than if there is some prospect of hope in the next 300 years, right? So it matters for an agreement on past compensation, what the next 300 years are going to look like. But the focus
Plan wasn't, or your plan wasn't, or your request was not to come up with a process for future negotiations.
No, it was geared for a process to identify past compensation.
Thank you.
Turning to our remedial approach. I want to turn to the Supreme Court of Canada decision and first start at paragraph 275. Supreme Court of Canada reminds us that to respect their constitutional status, uphold the honor of the Crown, and advance reconciliation, Aboriginal treaty rights can be no less enforceable than other constitutional rights, referring to Sparrow and Vanderpeet. As the guardians of the Constitution and the guarantors of constitutionally entrenched rights, courts are responsible for ensuring that Aboriginal and treaty rights are protected by adequate, effective, and meaningful remedies. That's the court's role overarchingly. And at paragraph 12, the court says, and this is about what this court's jurisdiction is or what it should be doing. Given this direction, stage 3, if required, must be modified in accordance with these reasons and would function as a review by the courts of the Crown's process in determining the amount of compensation and the amount determined, both of which must be just and honorable. If the court finds that the amount determined by the Crown is not honorable, it may require the Crown to redetermine the amount or set the amount to be paid by the Crown, lest the Crown continue to undermine the very object and purpose of the treaty promise. So it is within your remit to decide it yourself, should you think it appropriate. And in terms of the creativity and flexibility available to you, Takuhikan, which I'm not going to turn up all the paragraphs again, it well and clearly gives you full flexibility to be creative. If there is no constitutional compliance, we are asking you not to remit it back, for the Crowns to either decide not to remit it back for further re-engagement. The Crowns have not shown any willingness to truly come back to the metaphoric council fire. A creative remedy would be to make the findings of fact necessary to arrive at a just and honorable past compensation amount, including, as paragraph 180 of the Supreme Court of Canada says, the findings in respect of the form, level, and aim of the sharing that the augmentation clause requires, and for the court to identify a range that the facts leads the courts to, and then for the court to actually pick a number for past compensation. Do what the Supreme Court of Canada said you had the right to do. At paragraph 310, they return and to the remit of this court, saying stage 3 will not begin as an open-ended judicial assessment of quantification of damages for past breaches. Rather, stage 3, if required, will begin as a review of the process in which the Crown has engaged in the substantive amount the Crown has determined as compensation to the superior plaintiffs. However, if the court finds that the Crown's process or determination was not honorable, it may consider the appropriate remedy, including whether to remand the issue to the Crown for redetermination, or at the amount to be paid by the Crown. That's just a repetition of paragraph 12, so it appears twice. Maybe they're trying to emphasize the importance of ensuring the court knows of its duty here. But asking the court to actually pick a number, it is kind of rough justice that because there's no absolutely clear mathematical correct number, but the court can figure out a range. And here's where reality fits into the equation. With an actual number the court gives, the parties can agree with the court that the determination is acceptable and there's no appeals at all, or there can be appeals, and there's going to be at least a year or so of space for the parties, if they're smart, to further engage on reaching a result that they can live with. But at least if the court has chosen a number and has identified a range, they've narrowed the discussion. Conversely, if this court is inclined to remit the matter back to the Crown or to insist on yet further engagement without specifying a number, in order for any engagement sessions to have any meaningful content, there needs to be significant judicial guideposts of what honorable engagement looks like, what it means in practice to return to the council fire of equals, and how the parties are to conduct themselves. To remit the matter back for further Vidal Anderson style, we're here to listen engagement process sessions can't be the answer. There would have to be detailed guideposts as to how the Crown would conduct itself in respect of such future engagement processes. And I expect, that because of the prospective nature of any such determination by the court and the possibility of it, I suspect you will hear from the Huron Legal Counsel on this very point about what returning to the council fire really means. The second thing, if you're going to remit it back, that you need to do is need to make significant findings of fact in relation to what the quantum of Crown benefits to be shared is, and the proper way for the annuity calculations to be retrospectively done for each year, and their retrospectivity of the calculations that are needed, and the fact that they are indeed calculations are to be found at Supreme Court of Canada, paragraph 10 and paragraph 294. Included in the findings of fact, we think, would be you would need to make rulings on the form, level, and aim of the sharing that the augmentation clause requires. Respectfully, this critical variable, how to come up with a share of the benefits captured in any 1 year in the past, remains part of the scope of the treaty right itself and is a matter for either the parties to agree upon to define, which they have not been able to do, or for the court to decide upon, just as the Supreme Court of Canada says you must. If we do not have the court's guidance or determination on this form, level, and aim of the sharing, we're left with Canada's 20% and Ontario's 133%, with no guidance on what the acceptable share should be or how it should be operationalized as part of the treaty promise. Another important historical fact that the court needs to rule upon is the quantum of the annual benefits captured by the Crown in each year that forms the pool of funds out of which Crown discretion could have been exercised.
On share,
Yes.
I won't remember precisely, but I thought the Ontario Court of Appeal was very clear, and possibly the Supreme Court of Canada was very clear that there is no predetermined share, that the treaty does not promise a set share.
No, it does not. And I'm not, but
So
I'll
I'll just see if I've got this. So you're saying just as the court must make a finding on benefits for the purpose of determining quantum, the court must make a finding on appropriate share for the past.
yes.
Okay.
All right. So let me, the problem is that any share, and I think Canada makes this point in its either argument or maybe in its decision letter, any share in the past can be expressed as a mathematical percentage. That's the problem. I am not saying that every single year has to be the same percentage. I am saying that every single year there has to be a share determined, and there has to be a way to determine it. And because of the passage of time, there needs to be a decision made. And I want to give you an example. In the past, let's just take an arbitrary year of 1925. Suppose in 1925, as a matter of historical fact, there was 100 units of benefit to share. Forget about whether it's millions, billions, or $100. 100 units to share. The Crown retrospectively in 1925 would be called upon to, or at least in 2025, has to turn its mind, and I guess the court does too. Well, what would have been the Anishinabe's share in 1925? Right? How do we know? Well, the Crowns might say, well, in 1925, here's some evidence that we have of extraordinary expenses that were going on. And here's why in that year, your share would have been 50 of the 100 units instead of 75 of the 100 units. Expressing, you could say that the 50% is not a mathematical share. 50 units is not a mathematical share, just happens to be 50%, right? But the principles on share, just because they can be identified as a percentage does not mean that there's no duty to identify what the share should be. Now, if this had been done,
I suppose what I'm pointing out to you is when you use the words share should be, and doesn't the court say it's what the share could be? That is what is in the Crown's discretion. That the court can't say the share, possibly on past compensation it can, but in the abstract, the court can't say what the share should be because there is no right answer before we get to litigation and a
that's correct. Yes, that would be correct. And indeed, prospectively into the future, and this is where there is no right share really resonates, because in the future there might be a World War III where the Crown says we really can't pay, even though there's a surplus in 2072. It's 2072. There's a World War III going on. We got to send, use all of our extra capital and all of our spending power where we're going into serious debt. We don't have the fiscal capacity to pay you today, this year in 2072. Let's talk again in 2073.
All right. But that reasoning,
yes,
right, for whatever reason, the Crown doesn't have the fiscal capacity.
Yes.
Is an explanation for how they exercise their discretion. It is not my understanding. I'm happy to hear you on this. My understanding is that the Crown does not start with a fixed share that it must meet and then explain. why it cannot meet.
Oh,
that.
I can accept that. Yeah, yeah. You don't have to, it's not starting with a fixed share, but there needs to be a share identified. And in the absence of the Crown's going through each year and saying, this is what the dollar amount of your share should be in that year, the percentage is just a proxy for the exercise of the determination. There's nothing magical about the percentage. What's magical is what the appropriate share should be. And the appropriate share, I don't shy away from saying that the appropriate share includes in polycentric considerations. But in the past, those polycentric considerations are spent. The only polycentric consideration in respect of the past is in 2025, given what we honorably should have, let's just again use 2025 and 100 units. If examining 1925 and the 100 units available to be shared, the Crown says, look at retrospectively, as the court has required us to do, we think you should share 75 of those units. And then they bring that 75 units forward using appropriate numbers to generate the loss, and it comes out to X. And they look at the number and they go, oh my gosh, X, I got some sticker shock here. That's a big amount. The polycentric consideration in 2025 is, I got other things I need to deal with. I have to find a way in 2025, how am I going to pay that? Right? Maybe I have to defer it. Maybe I have to pay it over time. Maybe I can't pay it now, and maybe I'll talk to my treaty partner next year. But that would be a present exercise of polycentric consideration about the ability to pay. And I remind you that both Crowns have insisted that there is no impediment today, 2025, to pay what is just and honorable. They have, the Anishinaabe have consistently said, and we'll see this when we get to their January 11th letter explaining the January 7th offer. If you have any fiscal problems, let us know. We are your treaty partner. We will work with you on any fiscal difficulties. But the Crowns have said there is no fiscal difficulty in paying. And I think in my factum, I even suggested that if they come to court as part of this review process and say, say, if the amount of the award is $35 billion, then yes, we would have fiscal problems. Then fine. We said we would talk about that. We have no hesitation working with the Crown. The Anishinaabe have no hesitation making sure that any fiscal necessity is looked after so long as they're not left in the dust. So until the Crowns say that their polycentric decisions 2025 or polycentric considerations in 2025 mean something for their ability to pay, we don't really have to be concerned about polycentric considerations in the past, because those decisions were made, and as we know from history, those decisions were not favorable to the Anishinaabe. Justice Hennessy, you had asked me a question about the share and how that fits in. I had actually completed my section on the, if you were going to remit it back, these are really important facts that you need to come to grips with.
Thank you.
Not that I'm encouraging you to do so, but these would be important facts. So The appropriate result and just result in this case is to find that the engagement session process and the quantification of past compensation are not constitutionally compliant. The relief we requested is set out in our motions material at paragraph 5. I don't see the need to go over it, but I am going to just summarize the big picture of what we request. 1, don't remit it back. 2, order the Crown to pay additional past compensation and specify what that amount should be. That's global past compensation to be shared among all 12 nations. 3, order additional compensation for Whitesand and Red Rock to recognize their unique incremental losses, which could include the remaining counsel fee to be paid of $73,861,729.92. That's the math. 4, if the court deal with remaining costs or such that those costs of 73,861,000 and change, or such portion of them that are determined by the court in a stage B as being fair and reasonable, assessed on a solicitor and own client basis, be the responsibility of the Crowns alone to relieve all the other nations from responsibility of digging into their own pocket to pay for expenses that should never have been incurred. And finally, order that if the parties can't reach agreement on the quantum of the fair and reasonable fees remaining to be paid, or the Rule 57 costs of this constitutional review, that the dispute in respect of those remaining 2 issues could be set down on motion before you for determination. You have great familiarity with the history of this case and would be the perfect person to figure out those matters. Supreme Court of Canada says at the end of the J, judicial forbearance should not come at the expense of adequate scrutiny of Crown conduct to ensure constitutional compliance. That's the Restool decision at paragraph 298. I want to take you through what our on the record offer was, the Anishinaabe on the record at tab 29. And I probably have about 5 to 10 more minutes if I should
Go ahead.
continue. Yeah. Our letter of January 11th. And the reason why it's important is because of what it shows about the Anishinaabe mindset and their willingness to compromise on the big issues. On the big issues, on every single big issue, they are willing to compromise substantially. And you can read this letter and you can see just how reasonable the Anishinaabe are being by compensating on the bring forward rate, compensating on
Promising.
what?
Promising.
What did I say?
Compensating.
Oh my gosh. Okay. Compromising on the big picture issues, compromising on the bring forward rate, which is the chief matter keeping us apart, compromising on what benefits count, compromising on how to capture the indirect capture, or how to recognize the indirect capture. And even compromising and saying at the Crown, that said, and notwithstanding that each Crown has found it possible to budget for multi-billion-dollar giveaways to voters in advance of upcoming election cycles, our clients are not blind to the fiscal challenges of paying over $35.696 billion in one lump sum. Our clients have indicated a willingness to work with the Crowns to structure a settlement to be paid over multiple years if it is necessary to permit the Crowns to balance the present needs of others in 2025 with the payment of just sum to our clients. Our clients have offered this further compromise, and we note that both Crowns have flatly rejected the idea of payment over time, respectfully rejecting a payment plan over time and then complaining about the fiscal difficulties of being required to make one large sum payment is not an honorable approach. When you look at...
You don't say that the court has the authority to make an order of payment over time, do you?
No, I don't. One of the options the court obviously does have is to say this is the amount and go back and figure out how it's going to get paid.
Which you are strongly urging the court not to do.
I'm urging the court not to do that because, quite frankly, that's what would happen if you did specify a number. Now, why do I keep talking about reasonableness, the reasonable approaches that the Anishinaabe took? It goes back to my favorite case of the week, Tacohican, paragraph 211. This is what the majority says. Given that the exercise, and this is the exercise of finding a proper resolution, proper decision, proper award by the court, given that the exercise is concerned with the relationship between the Crown and Indigenous peoples, it is important to be sensitive to Indigenous perspectives on the manner in which the relationship can be restored. In a leading text on the subject, author Robert Mainville, now a justice of the Quebec Court of Appeal, wrote that full consideration should be given to the Aboriginal perspective and measures should be taken to ensure that the decisions made are consistent with the long-term interests of the concerned Aboriginal community and with its survival as a viable, distinct culture and society. We heard a fair bit at the trial from, in the engagement process from Chief Tangi about the needs of just infrastructure alone. I've already taken you to that. While these comments were made in the context of a discussion of court-supervised compensation schemes, they are also helpful in determining the appropriate remedy for a breach of an obligation flowing from the honor of the Crown. And, given the new approach in Tacohican, could conceive of, I should go back to what I just said about, does the court have jurisdiction to order payment over time? I think in Tacohican, you probably do now, quite frankly. But I'm not asking you to exercise that discretion in this case. That does not mean that the representatives of an Indigenous community can decide in the court's place what remedy is appropriate in the circumstances. Rather, it is a matter of recognizing that Indigenous perspective in this regard is a factor that the court must take into account. The more reasonable the Indigenous perspective is, the greater the likelihood that the court will accede to it. In closing, the Anishinaabe approach and their quantification and the $35 billion amount, and together with the other things they have asked for by way of relief, is reasonable. You should listen to it, take it into account, and after you've considered all the evidence, both in stage 3 and what came out in the engagement session, we urge you that that reasonable approach contained in the January 11th letter is the right, correct, reasonable answer and fits within the range of acceptable outcomes. And it's time for a decision to be made, and for my clients, all 12 First Nations, all Robinson Superior First Nations, to put an end to this litigation, have finality, and move on and try and work on the relationship further for the future. Unless there's any questions, though, that completes my submissions.
Thank you very much. We'll take the break. 15 minutes, please.
We're sit down for 15 minutes. This court is resumed. Please be seated.
With leave of the court, my friends pointed out that I may have left the court with an impression I didn't intend to leave, and I'd like to just clarify it, make sure the court has my point, if I might. On the issue of polycentric decision-making in the present, I want to be clear that in the present, in 2025, in making its decisions about the past, it is open for the Crown to inquire about what would the share have been in the past. And it was suggested to me that I was saying there was no room for that kind of present day retrospective looking. I didn't intend to say that. But my point was that whether you look at it from year to year or whether you lump it all together at the end of the process and say, over the whole period, I'm just going to use a percentage share, a share. It's not necessarily a percentage that's driving it. It's a share of the units. That was the point.
Okay, thank you.
Good morning, Justice Hennessy. I am Spencer Bass. I'm one of the counsel that will be presenting today and tomorrow on behalf of what has been called the Contingent Interest First Nations. These are the 6 added party plaintiffs, being Big Tugong Nishnabeg First Nation, Netmizagamig Nishnabeg First Nation, Pays Platte First Nation, Long Lake Number 58 First Nation, Bingwi Niashi Anishinabek, and Binchatabek Zagan Anishinabek. And these are the 6 First Nations in the Superior Territory that maintain their claims for unextinguished Aboriginal title. And so just before I launch into my submissions, I'll alert the court that we have provided a oral compendium, and I must apologize, in the original version of the compendium and the one that was uploaded to Case Center, we intended to include the explanation letters from Canada and Ontario, and inadvertently included all of the appendices to those letters. which rendered it very long. So for the physical copy, I have removed all of those appendices.
For which I am grateful.
And I have provided the physical copy there. However, the page numbering, even in that physical copy, matches the digital copy. So if I provide page numbers and others are following along on Case Center or on the digital version, we should all be on the same page, quite literally.
Very good. And this should be marked as an exhibit, I take it.
Yes, please. And I provided an exhibit copy to Madam Registrar.
So exhibit B will be the compendium of the Contingent Interest First Nations.
Yes, please.
Thank you. So just let me make a note. These page numbers are consistent electronic version.
Yes, and actually, in fact, on the paper copy that you have, the Case Center page number is also included in the top right-hand corner.
Thank you.
No.
I need to reconnect.
Take a break, yeah.
Might I ask that we stand down for?
Yes. Thank you.
All right, you don't have to apologize. It's these,
The World Wide Web.
the World Wide Web needs to apologize to you.
Okay. I'm watching. Right now, no. Nothing is coming up. Restart the link. Yep. Clicked. Okay.
Thank you,
You're
Your
right.
Honor. On behalf of the Contingent Interest First Nations, we submit that the Crown had 174 years to act honorably and fulfill the solemn promise that it made to the Anishinaabe people in 1850. Instead, it showed a persistent pattern of indifference, and it left the Anishinaabe with an empty shell of a promise. The Supreme Court then gave the Crown another opportunity. 6 months to change their ways, prove themselves to be an honorable and trustworthy treaty partner, and restore the Crown's honor after so heavily tarnishing it for nearly 2 centuries. Unfortunately, we are back here today because the Crown did not heed the Supreme Court's directions. Their exercise of discretion, both the engagement process and the amount of compensation that they selected, is not liberal, it is not just, it is not honorable. It does not comply with the honor of the Crown or the rights of the Anishinaabe protected by Section 35 of the Constitution Act. As we will demonstrate, both Canada and Ontario have sought to construct a framework for compensation that benefits themselves, shields them from fully accounting for the impact of their conduct, and appears to a reasonable person to have merely been a way to arrive at a predetermined amount. And so our clients are asking for this court to finally put an end to this cycle. After 175 years of waiting, enough is enough. Our client should no longer have to plead with their treaty partner to finally do what it promised to do 175 years ago. Pleas that have continuously fallen on deaf ears. The Crown does not deserve yet another opportunity to try again. And that is why we're asking this court to do what the Crown has failed to do. Provide our clients with just and honorable compensation. Only that will achieve reconciliatory justice and allow the parties to finally move forward in the relationship under the treaty. So in terms of a roadmap of submissions from our side, I will go first and provide submissions on 3 points: the standard of review, how the Crown improperly failed to account for the losses suffered by the Anishinaabe, and that relates to their choice of the bring forward rate. And finally, what to do with the share of compensation for the Contingent Interest First Nations, including an appropriate interest rate to protect it going forward. Ms. Angelova will then make submissions on how the Crown failed to actually compensate for the years 2020 to 2025, and how the Crown failed to properly account for the needs of the Anishinaabe, which is the Supreme Court's factor number 2. Finally, then, Mr. Gover will discuss first the Crown's improper reliance on polycentric considerations, the Crown's improper use of the Robinson-Huron Treaty Settlement as a benchmark, and then finally, what the appropriate remedy is in this case. Now, I don't propose to speak about the claims that Mr. Schachter spoke about for the top up for Red Rock and Whitesand, or the costs issue, the counsel fee issue. We've set out our position on that point briefly in the outline of our oral argument, which is at tab 1 of the oral compendium. I am happy to answer any questions that Your Honor might have about it, but otherwise we will not address it. Our clients are not advancing those claims.
Those claims?
Those specifically for a top up for Red Rock and Whitesand, and our position is that our clients have been fully indemnified for the engagement process.
And for the litigation?
So we are seeking our costs for this review. So our position is that we've been fully indemnified up until January 27th, 2025, and we are seeking our costs of this review, and that can be spoken to after Your Honor's decision. So moving on then to my first area, which is the standard of review. And our overall position is that for questions involving the scope of a treaty right, which is protected by Section 35 of the Constitution, and the honor of the Crown, this court must apply a correctness standard. And before explaining why, I will note at the outset, as Mr. Schachter did, that the standard of review really does not determine the result in this case. Our position is that regardless of which standard this court applies, the Crown's exercise of discretion cannot stand. And that is because it is not liberal, just, or honorable, whether you call it incorrect or unreasonable, and regardless of the amount of deference afforded, the decision is inappropriate. And that is because even on a reasonableness standard, which Ontario advocates for, and we say is not appropriate, the Crown's decision would be unreasonable for similar reasons as to why we say it's incorrect. For a decision to be reasonable, it must be justified and justifiable in relation to the legal and factual constraints that bear upon the decision.
I am going to ask you to slow down a bit. Thank you.
So in this case, The legal and factual constraints bearing upon the decision include the honor of the Crown and the purpose behind the treaty promise, including the parties' common intention. It includes the requirement of the Crown to exercise its discretion diligently, honorably, liberally, and justly while engaging in an ongoing relationship with the Anishinaabe based on the values of respect, responsibility, reciprocity, and renewal. Of course, I'm quoting from the Supreme Court at paragraph 197. So in this case, it cannot be reasonable for the Crown in its exercise of discretion to, for example, refuse to reckon with the losses it has inflicted on the Anishinaabe. It cannot be reasonable for the Crown to ignore central arguments, positions, and evidence raised repeatedly by their treaty partner. It's not reasonable to pay mere lip service to the Anishinaabe perspective. It's not reasonable to restrict the consideration of needs to those only in the present and thereby ignore the past needs. Past needs. These are just examples of constraints that would delineate the range of reasonable results in this case, and the Crown decision falls outside of it. So, despite that being said, given the importance of defining the nature of this review for the relationship between the parties, I will spend some time hopefully convincing you why a correctness standard is appropriate.
I didn't put this question exactly to Mr. Schachter, but I'll put it to you. If you want to rely on the correctness standard, does that mean there is a correct answer? And do you have that answer on both engagement and quantum?
So our position is that the correctness standard applies to certain questions in the Crown's exercise of discretion. So in answering certain questions, the Crown needed to be correct. For example, on the scope of the treaty right at issue. And so we do accept, and I will get there shortly, that there are questions as well where deference is accorded, as the Supreme Court said. But that ultimately, if the Crown has gotten it incorrect on what the scope of the treaty is, what the treaty right means, the decision that has flown out of that cannot be honorable and just, and it must be set aside. In terms of if you're asking me, is there a single answer to the exact penny on what compensation, what appropriate compensation is in this case, we would say no, there's not. And there is an honorable.
And I think the answer is, it's what must be correct is the range.
That's right. I would add to that, the range has to be correct, but the way of getting there has to be correct as well. The reasoning process. And so I wish to start here with the proposition that this review is not just a standard judicial review under traditional administrative law principles. We say it is a sui generis review process that was set out for us by the Supreme Court in its decision. And so firstly, the purpose of the review is different than a standard judicial review. In a regular judicial review, the court is ensuring that delegated administrative power, or that an administrative decision maker is acting in accordance with his, her, or its statutory grant of power. And as the Supreme Court taught us in Vavilov, the default standard of review is reasonableness because of the legislative intent to defer questions to particular administrative bodies. On the other hand, in this review, the purpose is to ensure that the exercise of Crown discretion is in compliance with the Constitution, including both the honor of the Crown and the constitutionally protected treaty right.
And do you know of such a review ever having?
I'm not familiar with a review process that is on all fours with what we're doing here today. And that is why we say it is sui generis. It is a process that the Supreme Court constructed, acting creatively, as they say, in order to find a way forward to just compensation and a just remedy in this case. And to that point, I do think it's quite notable that the Supreme Court never referred to this process as a judicial review. That term does not appear in the decision at all. And in fact, there are only two references in the decision to Vavilov, which of course is the leading authority from the Supreme Court on administrative law judicial review. The first reference is at paragraph 105, and that's simply for an analogy to why the correctness standard should apply to the appellate court review of treaty interpretation, and I'll return to that point in a moment. And the other point was at paragraph 154, in order to demonstrate that there's no such thing as unfettered discretion in the law, and that was to respond to Ontario's argument on the interpretation of the treaty. So those were the only 2 points where Justice Jamal refers to Vavilov.
So once was with reference to the Ontario Court of Appeals, a decision on.
So the first was
interpretation of
standard of review for treaty interpretation, appellate standard of review. And ultimately, of course, the Supreme Court selects a correctness standard that it applies in that case. And the second reference was in considering the competing interpretations of the treaty and rejecting the interpretation in favor of unfettered discretion, it refers to Vavilov. But in discussing the remedy, in discussing the review process that we're now engaged in, the Supreme Court doesn't cite to Vavilov, makes no reference to discussion of standard of review or principles of judicial review. And our submission is that is telling. But Ontario points out in their factum that if you squint at the decision, if you look at the decision in certain ways, some of the court's broad, generic statements about Crown discretion are similar to broad, generic statements that the court has made about discretion and deference in administrative law. But that is very surface level. If the Supreme Court intended this review to mirror a judicial review under administrative law, they easily could have said so. I have no doubt that Justice Jamal and the other judges of the Supreme Court of Canada are familiar with judicial review and their case law, their jurisprudence in that area. But rather than referring to that, they set out a specific and unique framework for these particular circumstances. The only real reference to administrative law principles, and the Crowns rely on them in their factums here as well, is the reference at paragraph 299 to mandamus. And it's at our compendium at tab 4, page 1317. And Miss Angelova has pulled it up because I think it is important to understand the context of this statement. And so starting a few lines down, just a bit above the highlighted portion there on the screen, Justice Jamal says, it is appropriate in this case for this court to order the government to repair the breach of its constitutional obligations while leaving it up to the executive branch to determine the best means of doing so. And then there's some citations, and then the court says, while not a perfect analogy, a direction to this effect bears a family resemblance to an order in the nature of mandamus, insofar as it orders that discretion be exercised without specifying exactly how. And so this reference was in the context of the court's discussion of ordering the Crown to finally exercise its discretion to provide compensation after 174 years of the Crown refusing to even consider increasing the annuities. And so, of course, this reference has nothing to do with the standard of review on this review that we're now engaged with, for now that the Crown has exercised that discretion and the court is reviewing that.
You say these last words. Oops. Could that go back up on the screen, please? You say these last words in the first highlighted section, while leaving it up to the executive to determine the best means of doing so, has nothing to do with the order to exercise their discretion in this case?
So that referred to the Supreme Court ordering the Crown to enter into a 6-month engagement process, and if no settlement arises, you exercise your discretion at that point. That's the context of where the Supreme Court made these statements, in the context of the remedy that it was considering there. But in terms of, okay, now the Crown has exercised that discretion and we've returned to court.
Oh, in the review process.
In the review process to say, was that exercise of discretion constitutionally compliant? Was it honorable, just, liberal? These statements don't apply to that.
Well, do they apply to they apply to this court's review of the Crown's conduct in the engagement process? Should the court be looking at the permission, if I can call it that, for the executive branch to determine the best means of doing so?
Yes, that is a factor. That is a factor. And the Supreme Court does say that certain aspects of the Crown decision, the Crown exercise of discretion, is entitled to deference. And I do want to look at those in a moment, but there are other questions where we say, well, the Crown has to get that right. And so the point that I want to make here is that this court, in this review process, we can't just automatically transpose principles of administrative law and say, okay, this is a judicial review, let's apply Vavilov, let's treat it as a regular judicial review. We can draw on certain of those principles where they are appropriate, and we'll come to that in a moment. There are certain principles where we say, drawing from the jurisprudence of administrative law points towards a correctness review. But it would be incorrect to simply say that what we are engaged in now is just a standard judicial review and simply apply the default of reasonableness from Vavilov. And so we submit that the correctness standard must apply to constitutional questions. And that is actually because regardless of the legal framework, the correctness standard always applies to questions regarding constitutional principles of the honor of the crown and the scope of a treaty right. Because the courts are the guardians of the Constitution, they must provide a definitive, final answer on these constitutional questions. And that this approach is universal in the law, whether in the sphere of administrative law or civil law. And in terms of the latter, we need go no further than the Supreme Court's own decision in this case last July. The court determined that the correctness standard applies to questions of treaty interpretation, and that was because of the constitutional significance of these questions. And that's quite clear at paragraph 108 of the decision. So again, I'm still in tab 4 of our compendium, but now at page 1229. It's on the screen as well. And of course, this was in the context of the appellate standard of review, but Justice Jamal writes that in this case, for example, this court has to interpret the scope and content of constitutionally protected rights and obligations that embody the very conditions on which pre-existing Indigenous peoples agreed to share their most precious gift, the land itself, with newcomers. An appellate court must be able to correct errors in the interpretation of those rights when necessary for Indigenous and non-Indigenous Canadians alike.
Okay. And can you tell me what paragraph you were at? Oh, there it is.
Yes, that was paragraph 108 of the Ristool decision.
Thank you.
And so that approach on the appellate standard of review is consistent with what the Supreme Court has also said in the context of administrative law. And for that, I will take you directly to Vavilov, which is at tab 6 of our compendium, and specifically at paragraph 55, which is contained at page 1359.
And your page references are to the.
So the page references I've been given are to the red page number on the upper right-hand corner of the page.
And what's
not
that red page number again? Is that the case center?
So that red page number that I've given you is the page number in the compendium itself. The larger, I guess, maroon colored page number above it, the E1 2029, that's the case center reference. If you prefer, I can give the case center.
No, that's all right. And what is the E1 1950 number?
That is the other case center page reference. I believe there's a case center often gives a master page number and another page number. So they are both to case center.
Okay, thank you.
So again, so this is paragraph 55 of the Vavilov decision in the context of the standard of review in administrative law, and it's under the heading of constitutional questions. And there, the majority of the court says that questions regarding the division of powers between Parliament and the provinces, the relationship between the legislature and the other branches of the state, the scope of Aboriginal and treaty rights under Section 35 of the Constitution Act 1982, and other constitutional matters require a final and determinate answer from the courts. Therefore, the standard of correctness must continue to be applied in reviewing such questions. And so Mr. Schachter earlier this week took you to the York Region case for similar principles. And of course, there's discussion in that case about that line from paragraph 55, other constitutional matters. In fact, I don't even think we need to go to other constitutional matters, because if you look right before that, the Supreme Court explicitly identifies the scope of Aboriginal and treaty rights under Section 35 of the Constitution Act. And so for these same reasons, we say that the court cannot defer to the Crown on delineating the scope of the treaty right or the obligations demanded by the honor of the Crown in this case. And so just to be clear, the question here is not about whether the executive has justified a breach of a constitutional right. And often in the administrative law context, we see that question arise when it's asked whether the executive has properly balanced a charter value with the legislative scheme and can therefore justify an infringement under Section 1 of the charter. That's the Doré framework in administrative law, where deference is applied. But that's inapplicable here. That's not the type of question that we're dealing with. So I'll return to what the Supreme Court said in this case as well at paragraph 262, where they said that for well over a century, the Crown has shown itself to be a patently unreliable and untrustworthy treaty partner in relation to the augmentation promise. It has lost the moral authority to simply say, trust us. But despite what the Supreme Court said there, that is exactly what the Crown is now asking for. They're returning to court and saying, trust us. Defer to us on the determination of the scope of the treaty right that we breached for well over a century. And we submit that this court cannot and should not do so. On the question of standard of review, actually, both Canada and Ontario in their FACTA agree that questions regarding the interpretation of a treaty right should be subject to the correctness standard. And that, I think, refers back to both the language from the Supreme Court in this case and from Vavilov that I just quoted. But they then take the position that, well, but the Supreme Court has determined the scope of the augmentation clause in this case, and therefore, all that we have left is quote unquote implementation. And in that area, the Crown is afforded deference. And just, we don't have to go there directly, but I draw that from Ontario's argument at paragraphs 79 to 80 and Canada's argument at paragraph 17. It's a similar argument that they both make. And this is incorrect. Firstly, we don't agree that the implementation of treaty rights is something that the courts must defer to the executive on. Indeed, the duty of diligent implementation is an obligation that flows on the Crown, or it's an obligation on the Crown that flows from the honor of the Crown, a constitutional principle. And diligent implementation, particularly in this case, is deeply and it is inextricably tied to the treaty promise itself that is being implemented. And secondly, I would challenge the premise of the Crown in this context that the Supreme Court did not exhaustively resolve every issue regarding the scope of the treaty right. And to the contrary, the court expressly said that they were not doing so. And I direct your attention to paragraph 180 of the Supreme Court decision. Again, the Supreme Court decision is at tab 4 of our compendium, and the paragraph 180 appears at page 1261. I think Mr. Schachter took you to this paragraph as well. And Justice Jamal quotes from the Court of Appeal majority: the parties in negotiations or the trial judge in stage 3 must determine the form, level, and aim of the sharing that the augmentation clause requires. Then at the end of the paragraph, the Supreme Court agrees with this principle, subject to its discussion of the appropriate remedy. So the Supreme Court was saying here, we are not definitively determining the form, level, and aim of the sharing required by the treaty. We are not determining the full scope of the treaty right.
But on the question of deference, do you go to when you go to the last line that ends with subject to the discussion below regarding appropriate remedy, do you say in that discussion below there is anything that leaves or affords deference to the executive on the final determination of form, level, and aim?
On the scope of the treaty right, on the form, level, and aim of sharing, no. The remedy that the court adopts is 6-month engagement process and then the exercise of Crown discretion.
The Crown or the court order? You say the remedy that...
The remedy that the Supreme Court provided, when Justice Jamal is referring to subject to the discussion below and the appropriate remedy, and then the appropriate remedy is engage, negotiate over 6 months. If you can't reach an agreement, the Crown must exercise its discretion. And so in that exercise of discretion, the Crown does, of course, have to take a position on the form, level, and aim of sharing. Ideally arising out of that engagement and what it heard from its treaty partner. In order to implement, it must make a determination, make a decision on what it believes the form, level, and aim of the sharing required by the treaty to be. And then, as the Supreme Court said, part of that, the remedy that they're ordering is that if the First Nations are unsatisfied by that, they don't believe it achieves reconciliatory justice. Of course, the Supreme Court doesn't use reconciliatory justice in the Restool decision, that comes a bit later, but that the First Nations can return to court and the court can scrutinize and review that exercise of Crown discretion for compliance with the Constitution. And so on the point that the Supreme Court did not exhaustively interpret the treaty right at issue, I would point out, of course, that makes sense given the context in which the court came to the Supreme Court of Canada, right? It was an appeal from this court's stage 1 decision, which was not meant to be a comprehensive interpretation of the treaty right. It was a partial summary judgment motion on particular questions. It's why in the stage 3 trial that proceeded in 2023, we called evidence from chiefs and elders to speak to the Anishinaabe perspective on the form, level, and aim of the sharing required. So as with other determinations of the scope of a treaty right, the Crown cannot have the final word. It is not entitled to deference, and the Constitution demands that the court be able to step in to correct incorrect interpretations, to correct wrong interpretations. So the Supreme Court did recognize that the Crown is entitled to deference on certain questions, balancing polycentric considerations, considering the wider needs of other populations. The Supreme Court said that. We accept that, of course. But, and this is what I was just speaking to, throughout the determination that is being made in order to arrive at the question of what is just compensation in this case, there are certain questions regarding the scope of the treaty right and the obligations of the honor of the Crown. And while not a perfect analogy, these are analogous in some sense to an extricable question of law or an error in principle. If the Crown has adopted an incorrect understanding of the scope of the treaty right, the resulting answer that it gets to will very likely be unsustainable. So to help illustrate this point, I would go to some examples, and these are in no sense meant to be exhaustive. But for example, the question of, does the treaty promise, or does the promise to share in the wealth of the land, if there's wealth to be shared, does that refer to only net Crown resource revenues or directly captured benefits? Or must the Crown consider and share benefits that it receives indirectly? And that's a question of the scope of the treaty right. Does the honor of the Crown require the Crown to consider and account for the losses suffered by the Anishinaabe and attempt to put them back in the position that they would have been but for the breach? Ontario says that's not the purpose of compensation here.
But for position.
Well, we would say that that's not a question that this court can defer to Ontario on. That goes to the obligations of the honor of the Crown. It goes to the scope of the treaty right. Must the Crown consider the needs of Anishinaabe people who lived and passed away in the past? So as I noted before, of course, the Crown has to take a position on these matters in order to exercise their discretion. They can't exercise their discretion otherwise. But because of the constitutional status of these questions, this court must be able to step in if they got it wrong.
So to short form it, do you say that a bring forward rate cannot be a matter of Crown discretion?
Perhaps there's a more complex answer to a simple question. Certainly the question of does the Crown have to account for the lost opportunity of the First Nations? That is a correctness question, absolutely. That goes straight to the obligations flowing from the honor of the Crown. That goes to the scope of the treaty right. Now, the question that may flow out of that is, well, how do we adequately account for those losses? That is a question where perhaps deference can come into play. And I'll speak in a second as well, but deference doesn't mean free rein. Deference still means a range of reasonable outcomes.
Or another way to put that is deference is not unfettered.
Absolutely. Another question that arises, and in Ontario's argument, they say that while in exercising our discretion, the minister took positions on the meaning of Anishinaabe principles. Like, what does reciprocity mean? What does Minobamaduan mean in this context? And again, we accept, of course, the minister had to take positions on those issues in exercising his discretion. Again, we said that should have been done in engagement with our clients, hearing from our clients, engaging with them on what they had to say about those principles. But then in exercising the discretion, the minister has to take a position on them. But then Ontario, and it's a paragraph 229 to 238 of its factum, it then says, well, this court should defer to them on how they interpreted those Anishinaabe principles. And we say that's an absurd argument. Ontario obviously has no expertise in Anishinaabe law, principles, and practices. And this is not the expertise that the Supreme Court was referring to when they referred to the scope of deference and discretion here. So again, the Crown engages with the First Nations on these principles, takes a position on them in exercising its discretion, but then this court can, and we would say must, be able to step in if they get it wrong. And so, as I just noted, even where the Crown is entitled to deference, even where we accept deference is appropriate, that doesn't mean free rein, it doesn't mean unfettered discretion. In the context of reasonableness, that is the deferential standard in administrative review. Vavilov tells us, well, even reasonableness is a robust form of review. But rather than rely on Vavilov here, I'd prefer to rely on the Supreme Court's decision in this case, in Restool, where it says that the court must still ensure that the discretion is exercised liberally, justly, and honorably, and in accordance with the purpose of the treaty promise.
And that is paragraph
308. I note the time. I have a few more points on standard of review before moving into the next area, but happy to take the lunch break now if that's the court's preference.
Okay, why don't we take the lunch break? I would like to meet counsel in the, there's a jury room just at the end of this hall where we've met before. If we could just have a brief meeting there.
All right.
Oh, sorry, this is the break we're off. Thank you.
This court is sit down until 2 p.m.